were the party, so our writ was dismissed by relying on this very judgment, which was recalled in a review, and now the judgment is reserved in 23rd of November. So our writ was dismissed solely on the basis that earlier that appeal was dismissed.
But the MA to be considered after the judgment in the case of so and so is pronounced.
Yes, grateful Lordship.
And then sign it, and you circulate it after that judgment is delivered.
Grateful Lordship, we do that. Grateful.
So now everything is over. Please.
Therefore, you should not have unnecessarily wrecked up the issue by filing a contempt petition.
I should not have filed. What I did was I made a complaint. They did not respond to it, but thereafter I filed that paragraph. Now let this paragraph 11 may kindly be expunged, page 11, 20,000 rupees.
Paragraph.
Otherwise, my career will be at. Yes.
If we are not inclined to interfere with the order of dismissal of the contempt petition.
Yes.
In as much as the matter is between the court and the alleged contempt. However, we set aside the directions issued in para 27.
Para 27.
Of the imperial order.
Well, now today everything is settled. I am working. But
you are working. Nobody has asked. You are now raking it up. They will come to know and ask for the contact certificate now.
That's what's deposited in the.
All these are self-invited observations.
May have been wrongly advised. That's all you can say. Since your lordship says expunged, will be obliged.
It's a very short prayer, but needful. Husband is not come before sign and open the locker in which my all jewelry as will other valuables has been stashed, and he is migrating.
Undertaking.
4 weeks, just to permit it.
Dusty may be permitted.
Yeah, that is what we have said, yes.
Obliged.
Connected matters.
Yes, matters will not.
Let him open up. Before you uttered a word, he said that it has to be dismissed. But it appears that somebody is watching online. So you want to make the presence failed.
No, your client. What my learned brother means here.
Yeah. Since the petition arises purely out of an interview order, we are not inclined to enter in the same. The same we reject it.
Okay, but somebody else is appearing.
20, because although this is an innocuous order, I'm complying with it, because she has got in fight with 3 IITians. I'm also an IITian, I'm converting oxygen from carbon monoxide. Now, even after the marriage, the FIR was filed saying that erectile dysfunction. And she files a maintenance case here in Delhi. Then thereafter, after marriage, 2022, 2024, there's an order of your lordship's court. We want to sort things out, Milord. Lord should see at page 53.
You want to go for mediation?
Something like that, Milord, because 3 IITians are involved. The other 2 were also IITians.
Why-
And the
why?
order is after my marriage.
Why 3?
The other 2, she was in a relationship with 2, they are all judicial orders.
What
And
has the
the-
IIT got to do with it?
I don't know, it's a coincidence, Milord. So what I'm submitting is, Lord, we'll go in mediation and sort things out, Milord. That way.
The learned counsel for the petitioner stated that there is a possibility of the matter being amicably settled between the party. Issue notice to explore the possibilities of amicable settlement. Returnable 4 weeks. Yes, we are issuing notice.
DPO.
Password done?
See my password.
Password. Get back then. Fresh matters में. Fresh नहीं है 21 minutes. After notice.
After notice.
21 is after notice.
20 minutes after.
Because the learned attorney was, learned solicitor was appearing in this one.
He was here just now.
You can put 1 minute.
We'll pass it over.
End of the board, kindly. End of the board, kindly.
What is it fresh है क्या?
Yeah, both are here.
मेरे पास वो नहीं आया because I was on height में था ना.
अच्छा है, 43 से है. 23.
Item 43.
Yes.
My lords, in distance learning education, I had an MBA from Judicial University, my lords, in the years 2006 to 2008. My lords, much prior to the controversy with respect to the DEC, which at that point in time was empowered for recognition of the open learning, online education, my lords. What happened subsequently, my lords, the judgments in Annamale University, etc., gave a certain completely different understanding about my course, my lords. I had my education was between 2006 and 2008. At that point, my lords turned to how the DEC had perceived it. The DEC, my lords, kindly turned to page.
Isn't there a judgment of this court in lift irrigation or something?
Yes, my lords, that is with respect to AICT, with respect to engineering and what.
Same thing, we'll say Open University MBA.
At the time when the DEC said ex post facto approval should be given for every university which applies for it. I was, whether
The Open University.
even to being in 2017 to be retrospectively applied to me when I had finished my course between 2006 and 2008, at which point in time, DEC, which was in charge of deciding the validity of my educational qualification, had specifically said, my lords, will kindly turn to that minutes of the meeting of the my lords, page 43 to 49 at 49. This is the minutes of the DEC, my lords. It starts at page 43. If my lords will see that it's a 33rd meeting of the District Education Council.
49, at 49.
Yes, District Education Council at that point in time, my lords, before there was a controversy with respect to the powers of UGC and whether the UGC regulations with respect to open education would apply. At this point in time, it was DEC which admittedly had authority. So DEC, my lords, says at page 49, starts at 48. Any other item with the permission of the chair? the issue of post facto approval of B.Ed programs or other programs offered by Jamia Millia during the period 2003 to 4 to 2006 to 7 was placed before the council. This was reported to the council that Jamia Millia had accorded provisional recognition by the DEC for offering programs approved by statutory bodies by the universities through distance mode for 1 year, that is 2007 to 8, till the visit of the expert committee. ICFI also, in fact, stands on the same footing factually, my lords. The council decided to accord post facto approval / recognition to Jamia Millia Islamia from 2004 3-4 to 6-7. The council also decided, this is important, my lords, council also decided to accord post facto approval recognition to all universities till 2006-7 who are
But yours is which year?
6 to 8. I completed between 6 to 8.
8.
Provisional was given, my lord. And in fact, when I filed this writ petition, my lords, 3 orders of single judges, all did to consider it on the basis of this. My lords, you see, there are 3 orders passed by the single judge. The final order disposing the writ petition was made on a completely different understanding on the basis of communications of MHRD to UGC in 2018, saying subsequent to the decisions in Annamalai University and Odisha irrigation, there is no question of any ex post facto approval being given by the UGC. This cannot work backward to a time when the DEC was giving ex post facto approval and all other universities which are placed in the same on parity have been given. So it was on the basis of parity and on the basis of the rules and regulations that were prevalent at that time that the single judge on 3 occasions.
Meeting of the Distance Education Council dated 7th October 2009, issue notice returnable 4 weeks, just to be omitted.
May I request a password in item 45? As well led by Dr. C.
Yours, other petitions say extending time for MBBS.
45, 46 board, they have actually taken up to deal with them.
So you are arguing 46.
46, 47, 47. But this concerns that our seat intake was increased on 8/11/24 from 150 to 250.
You are in 46.
So the seat intake was increased, my lord, from 150 to 250, and there were 103.
No, from 100 to 150.
That is in the first, my lord. That's in 2009.
And the delay is entirely by them. They every time I appeal, I win. In High Court, I win. And they ultimately agree to increase 50, not 100. And the delay is caused only by them. Just 3 days are also will I will get a second disapproval on 20, this is 45 days, like 45. The disapproval I get is 29 June 24. I win my appeal on 30th September. That's 3 days. 29 June, I get my second disapproval. On 30th September,
29 June? 29 June?
24, all is 24. 30th September, I win my appeal, get a remand. They take once on remand, a second disapproval. For that, they take 2 months till 5/11. Till 5/11. Just 2 more days. After that, I go to High Court and I win on 22/11. In hardly 15 days. From 22/11, they will dismiss me finally now on 4/12. With the last date for counseling starting on 5/12. So I have done it for. The only thing now is 50 more. Luckily, for courses to start there is time. For courses to start there is time. Counseling is starting, goes on till next month.
412, what is the order?
4/12 is saying, okay, after all your victories, my application being 100, I allow you 50.
letter of permission, but only for half. And one more very important thing. When they give me half, that's a Vishal that asked this question. They don't tell me why you not giving the other 50.
No explanation.
Reason. I have machine to call only the last day.
Apologies.
I am 45. This is 36.
In our student, we got the permission on 8/11/24. To increase from 150 to 250 minutes. That's page 41. Thereafter, the process took place. We have 9 vacant seats as of now. Just 9 vacant seats which you want to fill.
Over 10, if 6th it was, I think.
Last year, when we put the schedule, it is 46.
6th December, 5th December, 5th December.
Now that the dates are gone,
5th is the last date of council.
That's for counseling. The actual thing we go on for the whole month and earnings. Counseling staff.
no, what is the last date for admission as per the schedule?
5th. They extended it to 5th.
Yes, 5th. 30th date for downloading the allotment letters and admission, 30th to December. 5 days. Page 47.
Counseling, no doubt, staff are paid, but
No, admission ends on 5th of December, that's what.
5 days.
they make you pay for the lots of units are then.
Since the last date for admission is already over on 5th of December, we are not inclined to entertain it. Even 10 December, we are on 17th now. Extend हम ही करेंगे ना. तो at least I don't.
Camera stop my video.
Gaurav is here.
नहीं मैम वो 3 डॉट वाला जो ऑप्शन मैं आपको बता रही थी ना मैम.
What is it? 5th December.
For admission. Counseling, for counseling.
Counseling.
Only the list has to be provided of joining student by 10 December, otherwise 5th December.
But you also take so much time to follow orders of 22nd November to 4th December.
You know, facts of this case, I'm appearing in item 52, where there's 1 seat vacant. And then the trend is also here, I have instructions, they are compiling the data from all over India, how many vacant seats are there, then they will come to this.
So then we'll keep it day after tomorrow.
May have it on Friday.
Friday would be, cutting it to.
Because, yesterday only I had a word with them, so they are compiling it to take a call.
After, but 1 day we had my husband can day after.
Friday, we may have.
Let it go, but it will be difficult. You'll just see Mr. Sharma because
Item 52 also.
So 52 weeks.
We will just give our briefs to.
if it is approved cases, the expenditure will be same for them. Now income is getting diluted.
We will give our copies to BSM.
All the same.
All the matters.
Including 52 also.
Thorough tax relief.
49, this practice of delaying this, just because liberty is involved, time must come and the lordship must pass orders and say that you can't keep taking time for counter. The last chance is what the lordship used in the last order.
They filed a counter, we filed it last night. This now was 2 days to print it on them.
This is the.
We also have it on Friday. We ensure it's on record by Friday. We filed it last night.
9, 12, 20.
By of last chance discount system.
And can the counter travel beyond the charge sheet? Charge sheet is filed, is already annexed. What is the counter going to do?
We delineated his role particularly, Manas, given the fact that there is a.
Give us a copy.
Somebody who was had a transaction for 8 crore is on bail. He says his father's account received 1.45 or something. Is there any dispute on that?
I bow down my system. The difficulty is, Manas, remember statements that are placed on the counter are illegal. So we're in the process of translating it.
How is it able to forward then if it is in the process of translating it?
Manas, we filed it with a defect. That's the difficulty. Manas, may have it on Friday.
No.
This is a classic case where lordship has said logistics of delay. The judgments are there, Manish Sisodia, Javed Gulam, Vijay Nair, Kejriwal, and they say non-cooperation. My lords, for us, the judgment offered by Justice Gavai, has said this non-cooperation is a very strange phrase to use. They use it for us para 20, 19 and 20. And the co-accused is out. It's about amount here is 1.05 crores. The overall view your lordship takes in such matters.
May I only point out one fact, my lord? Even in Manish Sisodia, when Malod granted bail, Malod said long period of incarceration coupled with delay in trial, depending on nature of allegation. He was arrested on 16 July 24. He was effectively in custody only for 5 months yesterday. And Malod's held long period of incarceration. Even in Sisodia, Malod's noted.
No, that doesn't mean that we have to not
I'm
take into
not-
consideration the other factor, the prima facie case, balance of
I'm
convenience.
not saying that, my lord. My submission is only on this ground if my learned friend is pressing it.
No, Piyush Jain, Piyush Jain parity.
Parity, my lord, in 439 scenario, but even there, my lords have said, depending on the role of each person.
Yes, so
He
there-
only sees role, my lord, from the complaint.
Yes, show us the rule.
Yes, please have 267, my lord.
For the counter.
Yes, this is I'm showing the prosecution complaint from the main paper book. Well, the background of the case is that 2 tenders were awarded for 197 crore on the basis of fake certificates for procuring those tenders. There was one additional chief engineer who wanted to inquire into all this. These people got him transferred out. And my lord, he received a bribe of 5.14 crore, acquired 2 properties and cash, and showed in the books of account as purchased in 1996 when it was actually purchased in 2022. Now, please see in that context, my lord, the role and the investigation that we've done in his context.
No, you show us what is the role attributed to the present applicant.
Present applicant, 267.
He was the additional chief engineer.
No, my lord. He is one of the middlemen who is, my lord, acquiring the procedure. Friend, please see 267.
I'm a private person alleged to have given 3 point some crores. All in cash. All in cash, no evidence. Page 267. That's the entire allegation.
Yes, sir.
Yeah. Now, if my lord will see the investigation for him, it starts at 222. Please have 267 is the summary of his role, my lord.
Yes.
During the PMLA investigation, while recording. my lord,
You're reading 267?
No, I'll come to 267 and
No,
then I'll.
wherever you want, you just.
I was showing the material at 222 on.
We'll go there, we'll go
Yes,
there. Give me PDF page also.
PDF page is 252,
All right.
bottom.
Yes.
Para 10.1.9, during PMLA investigation while recording statement of accused, namely Padam Chand Jain, Mahesh Mittal and Piyush Jain and other individuals, it was found that Sanjay Badaya, despite not being an official employee himself, used intimidation tactics to coerce staff into carrying out unlawful activities that benefited himself and others and transferred those who did not agree to his dictates. Further, in exchange for bribes, he facilitated the transfer of employees. Further reference is invited in this regard to the conversation between Mahesh Mittal, the telephone numbers are marked and Shri Saini on so-and-so dates marked as serial number 7 on page 27 to 31 of the charge sheet in the FIR. This is the predicate case, my lord. And we'll not see the conversation. I will finalize that. Those are their bills. What are the rules of price selection tomorrow? I will sit there and do it. I'll take an hour sitting in your room. And then, my lord, will see. You come for 2 days, that is so and so. Yes, Rajeshji, it is a matter. I will sit there and do that. Mahesh Mittal, sir, get it done. I've called him many times for the payment. I've called him many times the day before yesterday. I've called him today also. And then, my lord, will see. Page 229, bottom. In his statement, he was asked, who is this Sethji that is being referred to constantly in this conversation? Please have that.
So he is not a party to any of this conversation.
No, but the conversation refers to.
We are asking him, Mr. Radhakrishnan.
Please have, my lord, para A at 229. When Shri Mahesh Mittal was asked during his statement tendered before the directorate under section 50 as to who is Sejji, he interiorly stated that Sejji is Shri Padamchand Jain. He further stated that Badaya refers to Sanjay Badaya, who managed PHED on behalf of the then minister Mahesh Joshi, that as he served as middleman of Shri Mahesh Joshi in the PHED, any contractor who wanted to get his work done in PHED had to approach him. That any PHED employee who did not agree to Sanjay Badaya's dictates were either transferred or a paid vigilance inquiry were initiated against him. Further, due to Sanjay Badaya's influence over PHED officials, he pressured contractors as well, that he used to extort monies from contractors on behalf of Mahesh Joshi and then the minister PHED. He did not have any significant source of income, yet he managed to accumulate substantial wealth through his role as a middleman by extorting from contractors. Both Badaya and Mahesh Joshi took 2 to 3% commission on the tender value. The contract, if any contractor refused to pay them, they would use their influence on PHED employees to harass the contractors and make it difficult for them to work. Badaya and Mahesh Joshi used to take bribe in cash. Badaya demanded that all contractors and engineers within PHED to bring any work related to department to him, and thereafter he, by his influence, would get the work done and would charge bribe. That he carried out all activities because Mahesh Joshi had given him complete freedom in PHED department. So, Lord, he was, apart from transfer postings, commission for the tenders that were being allotted. And please see, Lord, the statements are there at page 232. That there are transcripts of conversations, my lord, at 233, which have been placed, my lord, along with the statements which were confronted to the people. And his own phone call records at 234, my lord will see, when he was in regular touch, despite having no official position, regular touch with chief engineers. At 234, 10.19.3, my lord will see. His mobile phone call records are placed as relied upon document. And the proceeds of crime traveled to his father's account. Please see 10.19.7 at 235, my lord, running into 236. 5.4 crore in cash paid to this gentleman. And monies also came into his father's account. And there is no explanation whatsoever for any of this. He has no legitimate source of income. He is misusing his proximity with the minister. And, my lord, there is ample evidence to proceed. The only thing is
whether this ministry also made an accused.
Further investigation is
Yes.
going on.
No, answer is no.
Further investigation is going on.
Mr. Zoeb, apart from my brother's question, one more. 10.19.7.
Yes, Lord.
Piyush Jain appears to be the bribe giver.
Piyush Jain, one of the many.
One of the many.
One of
No,
the many.
no. So he is on bail.
Yes, please have that bail order, my lord, for a moment. Piyush Jain, my lord. That, my lord, additional document, page 6.
Additional documents filed by them.
Filed by them.
Okay. Yes. Page?
Page 6. Yeah. In page 6, my lord will see, on the peculiar facts of the case, my lord, have granted him bail. At page 7. And there is not, except for the fact, my lord, that complaint already filed. There is no other.
Is 8.87.
And
Crores laundering. Basically, the sum 1.2.
Let it go before the same bench.
Again,
Let it go before Justice Sundaresh.
so just 2 minutes. Number one, your lordships passed an order in a Kavita case where the allegation of 100 crores in the same 5 months because there was no direct evidence allegation. Number two, in that judgment, your lordship's bench observed that merits like this are not to be considered. Number three, any and every one of this, nothing direct against me. The only thing he points out is 234 where the telephone records show call is made, no transcript. The entire amount is 3.03. The whole case is page 267. Now, there's two people. One, the minister is not arrested. Piyush Jain has got bail. The amount in my case is 3.03. And the only statement he relies upon is co-accused. Your lordship takes a holistic view, Manas. And what he read just on Piyush Jain, that is not because the ground to your lordships are getting bail matters distributed because the lordship is entitled to follow that order on the contrary.
144 also, my lord, may see father's account gets credited with 1.07.
And that is refunded. That money is refunded.
It will be refunded when invested.
Before the ECIR, before the predicate offence FIR, I'm sorry. 5 of these facts are enough. Total amount is 3 crores. 8 crore person has bail. Piyush has bail. The 1 crore given to the father is returned before the predicate offence FIR. Forget the ECIR.
Property purchase.
And your lordship is direct judgment was here, which is to be followed. It doesn't mean it's to go to any bench. The lordship is entitled to do great respect.
Property purchase backdated to show that this is not a purchase from proceed of crime. Backdated to 1996.
Investigation is also over completely.
Page 144, my lord, may see the amount that goes into his father's account. 1.05 crore. Hari Narayan Badaya.
What is the stage of the trial?
Yes.
The charges are framed.
50 witnesses, 8,000 documents.
Charges are yet to be read.
Investigation against me is complete.
This is not a case, my lord.
Don't you think that he will
Yes,
change the predicate?
What is the difference between him and Piyush Jain?
Yes, Piyush Jain,
Not going to accuse the predicate of.
I can place that Piyush Jain prosecution complaint is not placed, my lord, here. I can place that complaint also, and that is not on record.
No, you just distinguish the role between the two.
Yes, we can do that.
You can do it now.
I'll place that.
When he has raised the ground of parity, he should have been ready on that aspect.
Yes, I can straight away, my lord, because that.
You show us what are the allegations against me.
Mr.
Mr. Ranchani, we have forgotten all good and good Bombay and Goa practices. I would now fully become a daylight.
Lord Piyush Jain, if I can just broadly summarize what his role was from the prosecution complaint, which is not on record. Lord, he was involved in managing bill payments of the firms by influencing PHED officials through bribe, as per his conversation, and he is a charge-sheeted accused.
So same allegation.
He was in receipt of, Lord, proceed of crime of 8.80 crore in his bank account from various
He is
firms.
worse off then. He is also in the predicate offence.
He is also in the predicate offence.
He is not in the predicate offence.
No, he is not in the predicate offence.
No, he was the director of the company, Piyush, which gave the bribe.
That, my lords, have held stuff. My lord, in Pavana Review, my lords take the view that.
No, that is not required. Legally,
That did not impact.
no.
Yes.
As long as laundering is there and some accused are there.
That's right. That's right.
That is
Because
clear.
strictly speaking, the allegations to him is that he was the receiver of the proceeds of crime on behalf and the behest of the minister. He was a conduit.
Ministry is not but an accused. What is the amount which is attributed to him?
Well, the total proceed of crime is, my lord, to this person, my lord, is almost 5 CR.
3.3. Page 267, 3.3.
3.30 and then 1.05 crore that is
His
received.
father.
Father.
The father is also accused.
Father is not made an accused.
The application is vehemently opposed by
Yes.
the.
In fact, even Pius Jain's statement is there not against him.
The learned counsel appearing on behalf of the respondents. The petitioners are basically relying on the order passed by coordinate bench of this court in criminal appeal number 3754 of 2024, dated 9th of September 2024. We find that the allegations made against the present petitioner are almost similar with the allegations made against the Pius Jain, who was granted benefit of bail by this court by order dated 9th of September 2024. As a matter of fact, the said Pius Jain is also arraigned as an accused in the predicate offence, whereas the present applicant is not an accused in the predicate offence. The amount attributed to the amount attributed to the said Pius Jain is in the tune of 8.87 crores, whereas insofar as the present applicant is concerned, allege that he has received 3.3 crores from proceeds of crime, and an amount of rupees 1.50 crores was also deposited in the account of his father. The further allegation against the present applicant as well as said Pius Jain is that he was facilitating awards of contract from PHED and receiving the money on behalf of the minister of the said department. Admittedly, the said minister has also been not made an accused in the present crime. With that view of the matter, we find that apart from that, the substantial evidence in the present case is in the nature of documents, and as such, there is no possibility of tampering with the evidence. All these documents are seized by the prosecution. The taking into consideration these aspects of the matter, we find that it is further to be noted that the charges are also yet to be framed. There are 50 witnesses involving and 80,000 documents.
8,000.
In the case, there are 50 witnesses to be examined, and the evidence contains around 8,000 pages. Also, as such, the possibility of the trial being concluded expeditiously is also removed, taking into consideration all these aspects of the matter, and particularly the order passed by coordinate bench in the case of Pius Jain, we are inclined to allow the application.
In the peculiar fact of this.
That is what we have said. Taking into, we are given reasons of.
Notice of the issue that is an extra period, and it is for completion of PDs listed on 25th of January. It's the same exam. Questions. Because there's one request I have. Kindly have an extra P9. So on one hand, they have filed an SLP which is pending. On the other hand, they are their contempt.
Issue notice.
Well, that's only one thing. Can I say I'm on caveat before your lordships? There were 7 questions which were challenged before the High Court. Out of 6 questions, this is the only question which has been upheld by the division bench. All other questions is now before your lordships. So, as far as this question is concerned, your lordships
don't proceed with the contempt.
Our only problem is that despite the learned single judge giving a judgment in our favor, they went ahead and made appointment based on the earlier result, and people who are not eligible as per the
What
judgment.
is this? Despite the single judge was going to give judgment in your favor.
No, it had already pronounced a judgment in our favor. Judgment was pronounced. Despite that, they gave appointment to people who were not eligible.
Yes, is it a matter of fact?
It's a matter of fact.
Kindly have P2. The Honorable High Court said you can. Kindly have P2. This is a wrong submission on his part. Kindly have P2. The Honorable High Court said.
Page.
Page, Malas, 219. Learned counsel appearing on behalf of the petitioner submits that on the basis of the result declared by respondent number 1, the appointment of respective posts are likely to be made under directions of respondent number 2 by various departments. Needless to state that in case the petitioner succeed in the instant petition, appropriate directions were
what is this?
to ensure
it's all subject to the.
No, I'm sorry. The judgment was pronounced by the learned single judge on 16 February 2024, and the appointment letters have been issued after that.
Where is that judgment?
Your lordships will have the judgment starts at page 2, and relevant portion is page 23.
This was still pending before the single judge.
And it is after this judgment that the appointment letters were issued. And the division bench, they have not placed before your lordships that order. The division bench actually said that you are in contempt, that without getting a stay, you could not have issued the appointment letters. They went ahead to issue the appointment letters, despite the judgment.
We both went before the division bench. The division bench had confirmed that one question, but they also challenged now before the Supreme Court. We both are here again. We are saying there could not have been any judicial review of the entire process. May I submit one thing?
24th April was in which matter?
Well, so these were different writ petitions filed by the candidates. Then there was an order. However, in the meantime, there was that even if you make appointments, it will be subject to, because there are so many vacancies, around 7,000 odd appointments have been made. And if, my lords, this is continued, that the questions and their answers are changed. Now, today they are before the Supreme Court saying that not one, but all 7 should have been there. We are saying not even one, because if you continue with this judicial review,
You should. So and so. In the meantime, there shall be stay of contempt proceedings.
I'm so deeply obliged. I'm obliged.
Mrs. Acharya is appearing online.
Yes, madam.
Please, your lordships, I am here, my lords. We are challenging the judgment passed by the Honorable High Court of Madhya Pradesh. My lords, in this matter, dispute relates to the admission to NEET PG exams. Examination was held in 2 shifts. And in order to, because in 2 shifts, the examination appropriate level of difficulty may have very, very minute differences. So therefore, my lords, the percentile system was adopted. This is a verified percentile system. AIMS has been using it for a very long time. We are at the fag end, my lords, of the admissions. On 24/12 is the joining of all the candidates all over India and in states. In states, the in-service candidates get some incentives. If you are working, you get incentives. For example, in Madhya Pradesh, they get an incentive of 30%. Now, your lordships, the Honorable High Court.
30% incentive or 30% reservation?
No, my lords, incentive. This is to be added to your marks that you achieve in NEET PG. So, my lords, as per our own method, which has been applied uniformly in all states, and which is a verified method to the last decimal system as much as possible. Because first the percentile is, the raw scores are converted into the normalized scores by converting it into percentile. And then Milos incentive is added. Now Milos, going into this deep mathematical calculations, the Honorable High Court has returned a finding that we should redo the list for the state of Madhya Pradesh. And this is based on a very erroneous finding at page 17, para 32. Your Lordships, the Honorable High Court has assumed the last three sentences of Milos para 32. The dispute pertains only to the state merit list for the state of Madhya Pradesh. We may note that there was no notification of the
As far as Madhya Pradesh is concerned, my lord, the petitioners have demonstrated that from the rank of 2000, my lord, they have come to 0. In the NEET, the NEET itself, the NEET list was that you have scored so heavy that you are list when all the parameters were equal, 30% marks were added. Now, suddenly, I have like a corporate wheel that they have not been able to demonstrate why they have not taken the normalized score in addition of incentive. That's why, my lords, have, in conclusion, the state merit list for NEET PG 2024 examination of state of Madhya Pradesh cannot be sustained and is accordingly quashed. National Board of Examination in Medical Sciences is directed to prepare the state merit list afresh, by not on the raw score but on the normalized. You have done normalization in an all India level. Now you cannot have a normalization again and again, my lord. The Honorable Supreme Court says, my lord, in a 5 judges decision of Honorable Justice Chandrachud, my lords have said it, you cannot do normalization in every stage. You have already done a normalization at the all India level. Your incentivized marks should be added on that. Why you are adding it on the raw score? The result is that a person who is 2000 above the merit, he comes to minus. And a person who was in minus, he suddenly jumps, my lord. That's why merit has suffered, my lord. That is my respectful submission.
We can't do that, what has been suggested, because that would be a mathematical disaster. Because normalized scores are percentile. And if we were to add 30%, 20%, in some cases it would go even beyond 100%.
But merit has to be looked after. In a medical matter, merit has to be looked after. You cannot say merit can be ignored.
Please, I didn't interject you. Because we have looked at the merit. And Milos, even in Rajasthan, where Honorable Division Bench has been pleased to intervene, that was because they relied upon this judgment. And Milos, in no other state this has been challenged or there is any other judgment. Now, Your Lordships, my learned friend who's present in the court can pass a chart to Your Lordships.
Yes, madam, we are already issuing a notice written about 4 weeks.
Milos, I'm seeking stay, Milos, because 24th December is joining, Milos.
We are already granted, yes.
Please, Your Lordship.
Highly obliged, Madam. Madam, Aditya Sanghi, senior advocate. Highly obliged.
Highly obliged.
Highly
If you want to use for respond number 1.
I am for all the private respondents. Highly obliged.
Item 52 minutes.
You have only one seat vacant.
Only one seat, Malas. This is through DGHS. I believe my learned friend, Mr. Banerjee, is appearing for you.
Yes.
So I don't know whether we will be able to accommodate.
Let Mr. Sharma come on Friday.
They are compiling all the vacant seats.
But I think once the entire process is over.
I'll see.
For some of the other reasons still there.
Lordship, in this case, the counter was filed and thereafter liberty was granted to the petitioner to file a rejoinder on the point of the criminal antecedent of the petitioner. Your Lordship, we have filed the rejoinder. Your Lordship, the objection on part of the respondents is that there are two other cases under section 307. The details of the FIRs have been mentioned at para 7 and para 8 of both the cases, Your Lordship, which have been objected to. Your Lordship, in both these FIRs, Your Lordship will see that in the first FIR, the allegation is against a mob. There is no allegation that anyone was either hurt or hospitalized, or Your Lordship. And in the second case, Your Lordship, it clearly mentions that it is with reference to the first case that the accused were involved, were present in certain place, and then the police approached them. And again, Your Lordship, the allegation is against the mob who have attacked the police party, Your Lordship. For Your Lordship, in the second case, the Honorable High Court was pleased to grant anticipatory bail, considering the no prima facie case being made out against the petitioner, Your Lordship. Now, Your Lordship, moving on from the criminal antecedents, Your Lordship, coming to the merits of the case, Your Lordship.
Yes.
Your Lordship, we have filed supplementary documents list, Your Lordship, in which the case diary has been filed. Now, Your Lordship, if we go through the investigation that has been done in this case, Your Lordship will see that on the 5th of December 2023, the offense is committed, and then there is investigation.